I've been sharing a lot of information with you of recent, published by my friend Barbara Weltman, America's #1 small business tax expert and the guru of small business taxes, as she is called by the New York Times and the Wall Street Journal. And as I was doing some research on Barbara, I came across a blog that she had written for the Small Business Administration. She's a regular contributor of blogs to them. You can find it at sba.gov. But the title of it is 5 Legal Myths About Startups. And since we are very much concerned about starting a business here in David's Barter community, I wanted to share with you her thoughts about legal myths. We hear so much about Barbara and her tax expertise, but she actually is an attorney, and so I'm always interested in finding her perspectives about things, legal concerns to small businesses. So here we go with 5 legal myths about startups. Last year, more than 565,000 businesses were started in the United States. The majority will make it, at least for a number of years, and some will not. And unfortunately, many owners believe certain myths about starting and running a business. And it is pursuing these myths that sometimes really undo business plans, business objectives. So let's take a look at it. Myth number 1: you can do it yourself. When getting started, many owners try to save money by doing everything they can by themselves. They form their own corporations, Barbara tells us, or limited liability companies, LLCs, as I have done. The last 3 legal entities that I have set up were LLCs. Pausing for a moment, whether or not I do it myself. I do some pre-research about it, but I make a phone call to a small business attorney friend of mine, Robert, and tell him exactly what my objective is. The first thing that he does is searches with the Secretary of State, in this case Ohio, to see if the name that I am interested in is available. And once he finds that, then we go to work, and I kind of fill in the blanks on a form that he sends me. Then he creates an LLC. From start to finish, that process takes us 48 to 72 hours, depending upon how busy either one of us is. So the myth about doing it yourself and how much you should do yourself, Barbara tells us that small business owners wanting to do it themselves form their own corporations or limited liability companies, LLCs, and write their own contracts and other agreements. She suggested doing legwork is a good thing to do, so that when you do go to an attorney, your billable hours aren't as great, and you certainly can save yourself a lot of money by doing some of the initial legwork. But there are 3 things that Barbara tells us that you absolutely need to turn to an attorney to do the work. Number 1, determining what type of entity is best for your situation, a corporation, an LLC, or a sole proprietorship. Up until about 7 years ago, I was strictly under the legal guidelines of a sole proprietor. But then some personal things were happening, and some things very significant to the business, different things than had occurred before. So Robert and I made the decision that it was best for me to form an LLC. The first LLC I formed was Dreaming with Entrepreneurs, which I believe is, there's a certificate on the wall, about 7 years old now. Uh, Number two, setting up the entity you decide on, or at least reviewing submissions if you choose to do it yourself using an online incorporation such as BizFiling and LegalZoom. BizFiling I've never used, but I've been on their site. LegalZoom I have used. You can get some very basic documents, contracts, fairly generic in their scope, but it really is a good place to start if you invest in one of those two, and they're both very, very good. You can create a document for yourself and then give it to an attorney to make it more precise, understanding the unique aspects of your business in the state or municipality where you incorporate. But once again, doing some initial legwork can save you a great deal of money. And then, quite honestly, attorneys, most of the attorneys I know would rather have it that way, that you do some of that legwork instead of depending upon them to do everything from A to Z. So something definitely to think about as you're starting your business. And point number three, Barbara tells us, is drafting contracts and other agreements for your business to use. I, very honestly, have made some mistakes in this area myself, where I was drafting things myself, and when it came time to test the document, the contract that I had created, it didn't always meet up to the best standards had I used an attorney. Some of the problem has been in the fact where I have been dealing with friends. I assume too much, and I've truly learned my lesson about dealing with friends and what needs to actually be put in writing. I've had some very ugly situations with friends in the last 2 years because I didn't do it the right way. Okay. Myth number two, a handshake seals the deal. Barbara's comment to this is, when you do business, it's great to have trust. Many in the diamond industry trade millions of dollars of gems on a handshake, but for the rest of us, paperwork is better. Oral agreements can lead to misunderstandings and can be difficult to prove in court, if not impossible to prove in court. You should put in writing the following two things that Barbara highlights. Agreements with co-owners, partnership agreements, spell out the terms and expectations of owners. Make sure you put that agreement in writing. The worst person in the world I think you could have a legal dispute with is a partner. And secondly, and more importantly, something I really can't comment on because I have never been involved with employee agreements. Make sure that when hired employees sign non-disclosure agreements, so they keep company secrets confidential. Not only employees, but whenever you enter into any kind of business agreement with anybody, make sure that a proper non-disclosure is in place. Last week I think I got it from LegalZoom, a non-disclosure agreement that I have an individual who is merely assessing what I have from a technology perspective. Before I would allow him to take a look at what I have from a technology perspective, it was mandatory that he signed a non-disclosure, and he had no problem with that whatsoever. A non-disclosure will protect you in the case that somebody takes information that they learned from you and they try to use it to somebody else's advantage other than yours. You must put in writing the following: sale of goods of more than $500, the sale of real estate, and agreements that take longer than 1 year to complete. Those have to be put in writing. Myth number 3, incorporating protects your assets. Barbara tells us many owners are under the misimpression that their personal assets are protected if they incorporate or form an LLC. While these entities do protect assets from the claims of many creditors, there are a number of situations where owners still remained exposed. And these are co-signing any company obligations such as leases, businesses, car loans, lines of credit, etc., not paying employment taxes to the government. If you take those taxes out of an employee's paycheck and you don't pay them to the government, you will be held liable for those, personally liable. And using a business as your personal pocketbook. If you fail to keep business finances separate from your own, then any creditor can set aside the legal protections you thought you had. Be very careful in that area. Okay, myth number 4, no legal protection for the company name is necessary. Barbara says maybe you've thought up a clever name for your company or product. Maybe you have a great tagline for advertising. The problem is someone else may have also had the same idea and taken steps to legal protection. Don't assume you don't need to seek protection for your intellectual property. And that, my friends, is becoming more and more a serious issue, particularly because the Internet is making more and more information available. So be very, very careful in protecting your intellectual property. And myth number 5, being small makes you invisible to the government. Not true. Businesses are highly regulated in the local, state, and federal levels. While some laws, Barbara tells us, exempt small businesses, many regulations apply regardless of the company size. Assumption that rules or regulations don't apply or that businesses won't get caught can get a business owner in very serious trouble and be very, very costly to you. And as a summary statement, Barbara's bottom line is, starting a business requires you to open your eyes and dispel the myths that can get you into trouble. When in doubt, don't fail to ask an expert. And Barbara reminds us, and I remind you very often, that the SBA has an affiliate organization called SCORE. And SCORE, they are retired executives, volunteers, express purpose, and they have years of business experiences. Their purpose is to help you with questions that you have, because if they don't know the answers directly themselves, they certainly know resources available to help you get those answers. Barbara, thank you very much for the 5 myths. If you want to get these in greater detail, you can find them at sba.gov and search for 5 legal small business myths.